way the people that's in front of us. So on my right, the first one is Pedro Vaca. He's the director of the Foundation for the Free Press in Colombia, and who will be presenting a case that we have in Colombia. To my right is Edison Lanza, who's the Special Rapporteur for Freedom of Expression at the Organization of American States, who will tell us the human rights framework that is quite unique, but it's applying to all the American space, and that could give us some light into the issues of freedom of right to be forgotten. Here to my left is Gisela. Gisela is from Derechos Digitales in Mexico, and she will be explaining some of the cases that had risen in Mexico. Marianne, from an academic point of view from the UK, will bring us back to what was some of the conclusions of the morning panel on right to be forgotten. And my far left, it's Kelly Kim, who's replacing the Professor Kim Seung from Korea, and she will explain us on the draft law that is evolving in Korea. Without further explanation, we hope to, once we have this panel and some small discussion, we will like to have a more active methodology, but we can always change some of the dynamics depending on the discussion. So I will start first with the specific morning discussion with Marianne, so that we can start drawing from there. Thank you, Marianne, for accepting this invitation, and welcome.
Yes, thank you very much. We had a very thorough discussion this morning that did not just include the people in the room. It included a group of students at Syracuse Maxwell School of at Syracuse University. And also we've had some very active interventions on Twitter from Julia Powles, who was going to be with us but could not be here. And I've also had some very interesting input from Gabriela Guillemin from Article 19, so we might try and leverage that in. I'm just going to provide you with the report that we've put together from this morning to refresh our memory. We had a wide range of participants a bit along these lines. Kelly was here, I was there, and Pedro at this end of the table was there. Sergio Branco from the ITS in Rio de Janeiro, Mishi Chowdhury from Software Freedom Law Center, and Henan Valles from the UN High Commissioner for Human Rights. Okay, so basically what we came up with is that, first of all, Pedro Andrade, who was speaking on the part of the Google Corporation, gave some background, first of all, for the Mario Costella case and the balancing act involved, public interest versus and private data. And he also gave some statistics of the sort of requests that Google has been receiving, at least from a year ago, which was around about 228,000 requests, and how they had to be evaluated. And of course, there had to be 824,000 more than that URLs checked. So very time-consuming and costly, and many experts involved. So his point was, of course, it creates a lot of work. And then Sergio Branco turned to the Brazilian perspective, and he pointed out that the current legislation in the Brazilian context is very vague, very bad laws, and he provided evidence to why they were bad, poorly written, poorly executed, very problematic with regard to the scope of what we were now calling de-indexing. What's the right balance with the devoir de mémoire, the right to the need to keep public archives public and to keep historical memory alive, and the public interest in issues around free speech, freedom of expression. Mishi Chowdhury emphasized how humanity as on the whole has a right to learn and to teach, and for her the right to be forgotten imposed a duty to forget, and poses nonetheless a cross-jurisdictional issue which is going to be and is being dealt differently in various regimes, which we're going to hear more about today. And then Kelly Kim here talked about the importance of these rulings for Korea, because lawful content has already been taken down under the guise of it being a right to be forgotten imperative. And again, very broad, vague concepts being diverted into other agendas. And then we talked about the issue of public interest. Pablo here talked about the right to memory and the flow of ideas, all of which are essential to a democracy. So we could be talking about a ruling that can start to impose a collective amnesia. And then the UN perspective was that we have different rulings in different jurisdictions, therefore there will be differences and disparities. There is nonetheless a right to know the truth, and this is a distinct right which is part of international human rights law, and we must work against the uncontrolled erasure of information, which has an impact, of course, on all our rights and fundamental freedoms. And all the panelists noticed the need for due process. And now I just, if you don't mind, Julia Powles came in by a remote to say that she thought it was disingenuous for Google to say it is a big burden without disclosing any information about the process that Google uses to vet and assess the various requests they get. She also mentioned that the vast majority, 95%, according to her, on the basis of leaked information she has, are extremely mundane requests to obscure someone's medical history or address. So we were faced here with the distinction between a private person and a public personality. And the Syracuse Hub pointed out that a case-by-case basis analysis would be an interesting option to explore. Basically, last point, we decided to get rid of the term right to be forgotten. No, we're not going to use that term anymore. We're going to say the right to be delinked or de-indexed by intermediaries. So we'll just say the right to be delinked ... But nonetheless, our hashtag is, wait for this, R2 as a number 2 BF. So R2BF. Hashtag R2BF. And there you will find all the tweets and be able to connect to the other tweets. So if you want to check up on that. Sorry to take so much time, but I felt that's the link into today's session. Thank you.
Thank you very much, Marianne. So to follow on this, I think that the next approach that will be very good to listen is the one from Kim, from Kelly Kim. She will present us on what's happening with the draft law in Korea.
Okay, I'm the first one. Okay. So yes, I'm Kelly Kim. I'm substituting Professor K.S. Park. So he's the expert, and I'm very sorry to miss him here. Anyway, so this discussion on right to be forgotten or right to be de-indexed or de-linked is important, especially for Korea, as Korean government, the Korea Communication Commission, which is like U.S. FCC of Korea, is considering adopting a right to be forgotten law since the Google Spain case came out. However, it hasn't been particularly successful yet because right to be forgotten in a broad sense is very well recognized in Korea already. So firstly, we already have a law under which an individual can compel intermediaries to take down information that is allegedly defamatory or infringing on privacy. Yes, and what makes this law similar to right to be forgotten decision is that information is required to be taken down simply upon allegation, very short of any proof of infringement. So every year, more than 200,000 postings are being taken down by the intermediaries, simply for reason that data subjects do not like the postings about them. So Marianne just mentioned stats from Google that last year about like 228,000 requests were received, and so you can tell how bad it is in Korea. And that means we have that many individual cases every year. Secondly, we also have an administrative agency called the Korea Communication Standard Commission, which exercises rigorous online censorship. Korea Communication Standard Commission is empowered by the law to make takedown requests on even lawful contents. So whenever it is necessary for nurturing sound communication ethics, any even lawful contents can be taken down by the Korea Communication Standard Commission. So this is a standard very vague and amorphous as a standard used by the Google Spain case, which are like excessive, obsolete, and irrelevant. So if you compare it to nurturing sound communication ethics, it's it's as bad as like Google Spain standard. And thirdly, we have criminal defamation law that punishes even non-privacy infringing truthful statements, which allows a data subject not only to make takedown requests, but also to criminally punish others for saying bad but true statements about you or about him or her. And fourthly and finally, we also have data protection law that may or may not give a data subject a blanket authority to demand data erasure about him or her. Well, apparently there aren't many such requests have made, so we don't have a court case yet. So I just want to underline that if we limit right to be forgotten only to the indexing from search, okay, we don't have any case yet. But like we don't need such right in Korea because there are many legal tools I've just illustrated that are used to expunge online information about yourself that you don't like. So to wrap up, we wanted to protect privacy through data protection law. We should not protect people's desire to wipe out unfavorable or embarrassing information about themselves. Think about a world where only favorable or like delightful information about a person lasts. I don't want to live in that world. Thank you.
Thank you very much. So to follow up on this, we will give the word to Edison.
Yeah, third? No, fine.
Final? You change, okay. So then Gisela, please, to tell us about the Mexican case.
Thank you very much, Carolina. Well, I think a lot has been said in this discussion about right to be forgotten, and I wouldn't like to repeat myself or repeat the arguments that have been made in the morning. I'm here to polemize a little bit. There's no solution. I just want to put different rights into consideration of this really badly called right to be forgotten. Just the disclaimer, in Derechos Digitales, we're not in, and personally not in favor of the right to be forgotten, but there are rights to privacy and dignity that have to be taken into account when talking about this issue. So first, a lot of the discussion has been centered around the right to be forgotten taken as censorship and pure censorship. And on the other part, I think Mr. Lanza will talk a little bit more about this, and I'm eager to hear that. The link of in Latin America between the right to be forgotten, memory, and our own democracy. The argument being, if I'm not mistaken, that our democracies, given the authoritarian past that we have been, the democracy is very linked to memory. So in this regard, I would just like to mention that in July, The Guardian published that less than 5% of the nearly 220,000 individual requests made to Google to selectively remove links to online information concern criminal politicians and high-profile public figures. The rest are just common, private citizens. And to make my case and polemize a little bit at the end regarding human rights, I will tell you about two Mexican cases. I think it's very important to discuss this in concrete terms because abstract discussions can sometimes make us a little bit lost. So the first one is very linked to this memory and democracy thing in Latin America, and it concerns a person named Carlos, I'm not going to say his last name, a person named Carlos that solicited the indexation of 3 links to the Data Protection Authority in Mexico that regarded frauds and corruption scandals that were also vinculated to the ex-presidential couple. So it is clearly a case where it could be a public figure, it is information of public interest, and nevertheless, he argued it in a way that he said his rights to honor were violated, even though the right to be forgotten originally doesn't serve to protect the right of honor, and the Data Protection Authority doesn't have anything to do with honor. It has to do with other things like privacy. So the Data Protection Authority gave him this right to be forgotten, And now there is a whole court litigation process going on about Google's responsibility in the process. The second one, which is, I think, very interesting and will take us out of the box a little bit, is a very recent case of a girl that had a WhatsApp group with 20 of her best and oldest friends from high school. And they had a sort of ice bucket challenge thing going on, but instead of ice bucket challenge, they were, quote, quote, in the context of the drug war in Mexico, which is really bad. They were playing a thing called Reto del Pasecito, doing the ice bucket challenge, but with cocaine. So she had an expectation of privacy. They uploaded all their videos. They challenged 3 or more of the friends that were in the 20 people WhatsApp group. And it was all very funny a year ago until her video got leaked. The Mexican press took it as a really big scandal that she's blonde and she was really well dressed in the video because she was attending a wedding. And they said it was a new fashion between rich girls in Mexico, and it became viral. So she is a kindergarten teacher. She lost her job. She has a PhD major in pedagogics. She lost her job. And after 15 years of professional career, when you Google her name, there's 15 Google results, the first 15 Google results regarding her cocaine scandal. So she can basically not get a job as a kindergarten teacher anymore. Why am I putting this concrete example? And again, I'm polemizing. I don't have a solution and I don't pretend to. As part of civil society, I don't think it's my job to do it anyway. So first, regarding the revenge porn mechanism that Google has implemented lately, it has been compared to right to be forgotten because it's basically the indexation, but let's just stop using right to be forgotten. I agree, it's just confusing. So in cyberfeminisms, and especially APC, which Derechos Digitales is a member of, we don't like the word revenge porn because porn is consensual, contractual, public sex. And revenge is not necessarily always adapted to what happens online we prefer the term the dissemination of non-consensual intimate images. So if you think about it like that, consensus is the center of the discussion here in the de-indexation of Google. And a Google representative just said it that way in a gender panel that was carried on a few hours ago. The second point, regarding this revenge porn, if we open the discussion to the dissemination of non-consensual images, there's 2 points that we have to make clear. One, a lot of burden in Google into deciding what is consensus and what is not. So there is a delegation of private powers to censor and to decide what to censor and what not. And the second one, which is very important, what is online consent, which opens a whole other degree of discussion. Secondly, the Manila Principles of Intermediary Liability require a judicial order to be able to restrict any content. And that opens another problem, the problem of access to justice. In places like Mexico, where justice is really slow, and we have a lot of problems with justice. And in America Latina, there's an institution, there's a general weekend institutions regarding every level of government. So how are we going to say that a judicial order has to be taken into account where marginalized societies and marginalized people don't always have access to all these remedies? And thirdly, let's talk about the algorithm. I mean, yes, we don't have a right to erase our embarrassing photos, but why isn't anyone talking how the algorithm is made? Why isn't Google making transparent how that algorithm works? Of course, patent law, thank you very much. But this is a whole other discussion, because if the algorithm is made so the links that get the most clicks are read as the most relevant, then the majority and enterprises are basically ordering all these things. And even if it's a private enterprise, Google nowadays is a system of public reputation. Our jobs hang on the line because, or thanks to Google. And even though a lot of, you could say if you're tech savvy, there's a lot of algorithm manipulation that you can do to counter all these things and measures, but not all of us are tech savvy. And we have, there's a problem of education here that has to be addressed, of consciousness and education of the permanency of our things in Google. And so that's just my point in polemizing the consequences and the possible impact that it can have on human rights in the online environment. Thank you.
Thank you, Gisela. So to follow up on the cases, we have Pedro from Colombia. Pedro Vaca.
Thank you, Carolina. Okay. It sounds? No. ¿Suena? Hola. Yeah. Thank you, Carolina. I think that the freedom of the press perspective on the debate of the right to be forgotten, or the link, I don't know how to this list, is perhaps one of the most interesting discussions that involve freedom of expression. When there is a desire of something to be forgotten, it is because someone has been upset by the information or data that has been published. And this means that the content is available to the public and includes negative information about or related to an individual or group of individuals. The wish to disappear is not a new wish. I mean, those debates has been solved, and those tensions has been alive since we have press. The issue is that on internet, certainly those tensions are intensified. So getting in the Colombian case, we are talking about a citizen identified by the court as Gloria. That's not her real name. She asked to a newspaper, I mean the biggest newspaper in Colombia, to remove from search engines, specifically Google, an article from 2000 year about arrest of several people for human trafficking, including her. Gloria was not convicted, and the case was solved. I mean, there's something that it's very common in our countries, like legal procedures takes too long, and you never know if the person is guilty or not. The process just finished with that doubt in favor of the person that is facing that judicial procedure. Gloria stated that the news article, and this is true, I mean, I agree with the Mexican case, that we cannot be solving or suggesting solutions for this problem without knowing that there are lives that probably are facing people that is facing situations that it's too heavy for keeping the daily life. So in this case, Gloria, because of that news, when she typed her name, she couldn't find employment or bank credits and all that stuff. So her life was not balanced with everyone, and she finished her doubts with justice, even if we don't know if she's guilty or not. I would like to say that when the Constitutional Court of Colombia took the case, we have to recognize the desire of understanding what technology is, how it works, which is the agenda of net neutrality, intermediary liability, and I think even if it's not so accurate, it's very important to recognize the effort for understanding it. And that's why the court found that easy access to the news article affected her right to honor. And for this reason, the court decided that when there is a favorable outcome for an individual involved in a legal proceeding, it is necessary to update the information and make searches more difficult, but do not delete the information. According to the Constitutional Court of Colombia, the media outlet must respond to the request and, if it's necessary, delink the content from search engines so that the information is updated and remains online but cannot be accessed through search engines. This rule, says the court, does not apply to people with a high public profile or public servants, or in cases of crimes against humanity or human rights violation. The issue that is controversial in Colombian case is that her case is about human trafficking that is considered a human right violation. So that exception was not taken into account in the same decision when says that when we are talking about human rights issues, it shouldn't be forgotten. We have also some concerns about the rule, the court rule. The first one is that we believe that we got excessive obligations for the media, and I think it's also controversial, this point. The court found that media outlets have an ex-officio obligation to update news articles about legal proceedings. So if you take into account that, I don't know, in other countries, media environment, but for example in Colombia, most of the news are related to judicial notes. So if you put the obligation of updating that information in each legal proceeding, it could become an excessive obligation for media and journalism. Think about small media, community media, an obligation that, I mean, they do not have one person in each judicial office for knowing how it's going. I mean, they are not lawyers, and the court think that journalists have to be like in the desk of the judge every day to know if they have to update, because it's an ex-officio obligation. This is a significant change that clearly differentiates requirements applied to the traditional press and to, if you compare it with to online media. So that, I mean, that's tricky for freedom of expression, because when you are promoting a freedom of the internet agenda, is not, I mean, you have to move forward in the agenda of digital rights, but also we have to keep the goals reached before on freedom of expression. I think is Colombian case went back in some issues we won before. The duty to constantly update articles. Update articles without any request is a disproportionate burden, especially on one considers a small media. Just finished, I would like to say that if I would have to point a lesson learned of Colombian case, I would say that we need authorities that are encouraged to learn which is the digital environment in which they are taking decisions. I mean, if they do not know how internet works, probably they are going to take wrong decisions, or they are going to take decisions more closer to what they think, and impartiality could be weak on those cases. So I really recognize the effort of constitutional courts, Colombian court, in understanding what was happening on internet, but I would like to target that we moved steps behind on issues about freedom of expression that shouldn't, I mean, we have to move forward on that.
Thank you. So last but not least, let's listen Edison Lanza from the Organization of American States.
Thank you. Good afternoon. It's a pleasure to be here. First of all, I would just say that in the framework of the Inter-American human rights system, there is not a definition about, the right of to forgotten. I think that it's amazing that all of the world it's speaking about that it exists this right, but there is not any declaration, any soft law document or decision of the, in particular, the human rights system that define the the content of this pretend right. And then the first thing is, I think that is a sexy name, but it's not a right, in fact. In fact, we talked recently that even the right of truth, that we are in favor that this is, yes, of course, a right that imply the right of the memory, the reconstruction of the history. But even this right, there's not also a definition about that. I think that we need to find a case in the Inter-American Court that progress in a definition about on regards of the right of truth. Of course, that the Article 11 of the American Convention protects the privacy and the right of the people to don't have problems about having an sphere of privacy. But the convention in the 1989 article said that in any case there are right must be supreme, el goce sería el disfrute,
The enjoyment.
enjoyment, the others' rights. And then I think that under this, interpretation, we need to find a solution for this problem. I think that the case Costeja and the other case that we comment in this summit, all of the day by day, it's really a form, a way to delete information, to supreme information, and even if you replace the case, the information that the European Tribunal ordered to delist or to cancel, it's a true information. It's not a false information or a defamation. It's a true information, and it's a important, it's a part of the public interest to publish some things of the private life, but in this case is regard the relationship between the people and the state, because the people who go against this information really have a debt with the state. And then I think that if of course it's perhaps not a very interest public thing, but I think that we must be have a reflection about that, because in the common life we have many acts that have a relevant for the public to know other person what is the way in conducting in the life. And then I think that in some sense Europe exports censorship, because this idea it's take about these other tribunals, like in this floor you held. And then if you read the case of Mexico that referred recently, after the decision, the IFAI, now is INAI, release a press release that says historical. We joined to the idea to write to forgotten. It's crazy. They find a case to put this concept in circulation in the region. And then, the third thing that it's, the case of Costeja have imply a idea that the intermediary is responsibility about all the information that flow about over these platforms. And this is another problem with the principles of the for example, the Inter-American human rights system, that we have, you know, many reports and declarations that they say the intermediary must be no responsibility for the content. Another problem that Pedro referred, it's like obviously Google is the most famous and powerful, you know, engine and a big company. But this case or this type of concept, after that it's applied at a little, you know, platforms or a media or another intermediary, and then I think that is another problem that we have. Well, for finally, I know that we have a problem because the last case that comment recently of Mexico is clear, you know, a new challenges of internet. But I think that we can apply, you know, the 13.2 of the convention that said any restriction of freedom of information or flow of information must have passed a test or free step. First of all, that it's a definition, a clear definition by law, and second, the objective of the restriction must be, you know, a legitimate interest that permit the convention. And the third step is in relation with the necessary for a democratic society, and you know, the must be have a proportionally in the sanction. And then I think that the case of Colombia, it's a good first step, because the court find a different way to approximate to the case. And the problem. And then I think that perhaps in this way we have the solution. For example, in these cases, add information or have a right to respond, and then the people we have all the information, you know, published to the city to make up opinion. Okay, thank you.
So I think just like this morning, but probably with other points, we've been talking about how the name is a big problem on the right to be forgotten, or the so-called right to be forgotten. We have heard some of the problems on what the issue with defamation versus freedom of expression and privacy are. There are jurisdiction and human rights issues. There is the issue of memory and truth as a way of trying to balance the issues. And both Gisela and Pedro also mentioned points on the problems of tech-savvy or digital literacy that authorities will have. So I think that we don't have enough time to break down to groups, so probably why don't we just open for discussion and hear some other points. Many of you on the floor are also people who know about this, so I would say that we just start a conversation here, make questions or comments. Because this is on a streaming, the people on logistic have asked so that you please stand up and come to the micro to speak. So I'm sorry if this is an inconvenience, but do please consider doing this. Shall we start? Is there anybody who would like to start with the comments or questions? Luis. Tal vez tienes que prenderlo.
Hi, good afternoon. Thank you for your presentations. Very, very interesting. And
Can you please say
yeah,
your name?
I'm Luis Fernando Garcia. I'm Director of Art3D, Digital Rights Defense Network from Mexico. I want to ask a question to Edison and just give a little bit of more information about the Mexico case. Disclaimer, our organization is challenging that decision on behalf of one of the websites, and that's what my question goes. So I think I was in the morning discussion as well, and I think there's, at least in the people that were here, but I'm sure that this is not, we shouldn't believe that this is decided, but most people agree that this concept of right before is problematic, I think, and not necessary as well. I think there are many legal ways in which, as Edison was mentioning, we deal with abusive exercises of freedom of expression. There's many legal avenues, right out of rectification, civil lawsuits for I don't know in English, moral harm. There's data protection interpretation, and probably that, I mean, the case that led to the discussion was developed on the data protection interpretation, and that's very problematic on many issues because of the intermediary liability repercussions. And I want to add one point that's what I want to ask. I just want to say on the Mexico case, I really do want to say the name of the person. His name is Carlos Sanchez de la Peña. You have the right to search for his name and see the news articles that relate himself and the company that he runs with corruption with former president. So you want to look for his name, Carlos Sanchez de la Peña, in Google. You can search for him. Because I think there's also a procedural problem with the data protection avenue. In the case of Mexico, the decision was taken by the Data Protection Authority. And basically was saying that you, Google, your intermediary, you should have given him what he wanted. So first it was a private decision, then it was an administrative body, not a judicial body, that made the decision. And in none of these decisions, another actor that is affected by this decision was present. So procedurally, it's problematic, and that is the plaintiff that I'm representing, which is the website whose link is being de-indexed. No? In this case, it was a magazine that has a website in which the magazine puts the news articles that they publish in their magazine. And I want to stress, for example, this has been recognized in both inter-American human rights law and European human rights law about the double dimension of freedom of expression. That is not, and the three activities is not only the right to express, but also the right to receive and to search for information. And in this case, de-linking, since Google is basically a monopoly in the search engine service, it really reduces the amount of traffic that this website gets. So it has harm also. I mean, this is not only about Carlos Sanchez de la Peña and Google. Google is challenging this decision, but we are also challenging this decision on behalf of the website that is suffering harm because its link would have been, we have a stay, so it's still there. You still can search for it, but the legal proceedings are continuing. But there's another party that is not procedurally part of the proceedings, either at the decision in Google that will have taken place or at the decision at the Data Protection Authority. And we're challenging the decision in the courts, and it's still up for grabs whether the court will recognize that we have legal standing to challenge that decision. I believe we do, because there's an obvious link about the right of the magazine to express and to make its information the most available possible, and this decision that affects it, and it would need to pass the test. No? So I just wanted to have some comments from you about that, about how all these procedural aspects need to also be taken into account when these adjudications of the rights are being done. Thank you.
Let's take a few if we have them, otherwise Edison will continue. Does anybody want to comment or ask any question? So let's go with Edison.
Yes, I think if we remember the case Costeja, and then after that the special group of the European Union that makes the rules of the data protection make a guidelines reinterpret the decision, because the decision don't care the problem of the public interest. If you revisit the decision in any chapter, paragraph, I have an elaboration about which is the border between the private information of the person and the public interest. And then I think that the authorities of the Europe say, well, okay, it's this so far, this goes so far, and then build this guideline that intend to have a restrict this concept, because I think that it's an amazing decision, and then with another instrument they intend to encapsulate this problem, no? And then another problem is like we know that now is built a industry to delete antecedents and the gross backgrounds, principle about person that have a dark history, and he want to apply to a public church or a political career. And I know many lawyer studies that they can now to litigate this type of case. I think that in the next edition, it's interesting to have here a person who defend this history, to have a discussion, a great discussion. But I think that really it's a very problematic concept, that to the flow to information and the access information by the people, and then it's a problematic case if this history, because I think that the court of Colombia have the problem that put the responsibility to this list, no, in Google, in the media, in a it's a no big company, and then I think that is not the solution, because the charge of this responsibility of the work in over the media, it is also a problem.
Regarding the recent comments, well, firstly, I agree that if Google were not as monopolistic as it is, this conversation would be very different. And the discussion of the so-called right to be forgotten is deterring this other discussion about Google's predominance in the search engine markets. We must put this on the table, and I would like to insist on this. Secondly, of course there can be censorship. Of course there is censorship. But recently in a debate about anonymity and dissent, the rapporteur of freedom of expression in the UN said that any tool for expression in the internet can be abused. So if we take, hypothetically, hopefully not, the right to be forgotten as a tool, it could always be abused as any other tool. So my only question is, and again, I am only here to put questions on the table and not be pro or against anything specifically, but why are we only talking about this 5% of statistics that violate the right to access to information and that talk about public figures and criminals, with complete disregard of the other 95% that are real human beings that are having problems because of this? Another point is that it has been argued, I don't know if it has been said here or in the morning, that anyone can be a potential public figure in the future. But I think this is so hypothetical that does not constitute a harm in itself on freedom of expression, although it is a threat. So just like to take these things into consideration. And lastly, the case about Costeja was of something very important that I think, again, terrible term of right to be forgotten is deterring, that talks about relevance. The Costeja case is a 16-year-old ad on a paper regarding an eviction that he was going to go through. But 16 years passed, so the other question that has to be put on the table is the right that we have to change. And if it could be consistent with the right to anonymity, is the right why is Google and algorithms deciding who a person is for an indeterminate time, like for a really long time? Like, why is that decisive? Don't we have the right to change opinions, personalities? Don't we have the right to disguise ourselves, to change our gender, and all these sort of things? So all these questions are on the table. I'd love to, if anyone in the public has more to say about this, I think it's a very rich debate. Thank you.
Do we have any other? Okay, please.
Hello, everybody. Giancarlo Frosio from Stanford Law School, though I'm a European scholar. I'm Italian, of the Italian nationality. And I just want to comment on I heard that Europe is exporting censorship all over the world. So on this point, I in part disagree. I substantially disagree, because I think that we should look back at the history of privacy in Europe. We should look back at an initial decision from the German Supreme Court that has set a higher standard of privacy protection, talking about right of informational self-determination. And so what has been happening with Google Spain is just the application of that broad principle of information self-determination, the principle that you have the right to determine what's going to happen with your information to the digital domain. And then, if we look at what happened in the last year, I think, and first of all, I think in the decision of the European Court of Justice, there were already the balancing measures there to be then applied by national courts. We have to remember that the European Court of Justice is not deciding on a specific implementation, is coming up with the necessary balancing of rights that courts must apply later on. And in this specific case, authorities. Now, there is then a long series of decisions coming from the European Court and the privacy authorities. And first of all, as it was mentioned by Article 29, which is the supranational European privacy authority, defining precisely how the balancing of rights must happen, and defining precisely that public interest should be protected, freedom of expression should be protected. And to give you the striking example of the fact that this balancing has already happened, you might have heard that the Spanish privacy authority said that Mr. Costella does not have a right to be forgotten, because now Mr. Costella has become a public figure. And so because he has become a public figure, he doesn't have anymore a right to be forgotten. But initially, the application of the right of self-determination was very right, because he was an unknown figure who had the right, who had a right of self-determining which information had to be online. But as soon as he has become a public figure, that right has been gone. And so this just to support the work of the European Court of Justice and European privacy authorities, and just to make clear that it was an intention it was the intention of European institutions to export censorship, but the intention was to apply this right of self-determination, and I think it has been done well, particularly in the year after the right to be forgotten. But then a question, and I'd like to open discussion to an issue that has not been raised, but which is very important, and it's also mentioned by the guidelines of Article 29, extraterritorial application of the right to be forgotten, because I think this is the key issue. You might know that the Article 29 mentioned that the right to be forgotten cannot only be applied to national domains or European domains, but must be applied to .com, so worldwide. And for then the CNIL, the French privacy authority, for the first time applied that decision to Google. Google never wanted to apply worldwide the right to be forgotten. CNIL applied one first time, imposed the obligation one first time. Google refused. There was an appeal against CNIL, ordered Google to apply the right to be forgotten on to .com, and Google still is refusing to do that. We don't know what's going to happen. This is then. It's not an issue only with right to be forgotten. We have been seeing in the last year famous case in Canada, always, also related to the listing, SQTech, courts asking for a worldwide application, so application of the listing orders to .com, to the .com Google website. And I'm curious to know what's happening in South America, because I see that there is a lot of emphasis on South America in this pain, and there are decisions. What is the stance? I know that in the Mexican case, the privacy authority decided not to apply if I'm not wrong, the decision to .com, but just on the Mexican domain. But I'd like to understand what's your take on this, where we should go, and if there is discussion about extraterritorial application of the right.
Thank you very much. We'll take also the question over there. Is there any more other one? You? Okay. So the three, and then.
So my name is Harold Feld. I'm also from civil society, public interest organization called Public Knowledge. I also, for the last 10 years, have been writing a blog on United States telecommunications policy. I don't like the term citizen journalist, but I will say that among other things, my blog has done things like trigger an independent investigation at the FCC over potential irregularities in the 700 megahertz auction. So it does have some value and contributes to what we're trying to do. So my concern is twofold. One is, everywhere we have had takedown notices or delisting type notices, we have seen abuses of this in order to prevent democratic discourse and in order to disrupt very timely debate. And the problem here is, so to take some examples, so I write some things about 5 years ago about people being paid to do reports for industry on network neutrality. Now the debate goes over to Europe. There is debate right now going on in Europe, or there was a month ago, and the companies that want to see particular things as precautionary measures simply submit lists and say, this was something that ought to be forgotten. To handle these things, they take place, in an automatic fashion. I have no idea. People who might be looking for information which was relevant about the U.S. fight that relates to particular people and what they did have no idea that they're not getting the information indexed. So even if I discover later and I have challenge process, the fact is debate is over now. So, if it happened 2 months ago, and I discovered it now, and I put it back up, well, the vote is over. So to the extent it might have done any good, it can't do any good. And these are not impractical things. I'm not going to pretend my blog would make a difference in the European debate over net neutrality, but my point is, we've seen this with DMCA, we have seen this with the ICANN process to pull down websites. We have seen constantly that companies will use these processes to disrupt conversation. My other problem is for people who are trying to do citizen journalism, because the information does not disappear, but Google and other search engines make it much easier for people like me to find, oh, this person 3 years ago worked for AT&T, now he's, fellow at Brookings Institute or whatever, and pretending to be independent, but I'm going to show that really he had past employment that makes the independence of his analysis suspect. So this person, when he decides to leave his, company, whatever, starts saying, don't list about my former employer, because now I'd find it very embarrassing. I would not be able to find this information easily. A diligent reporter would be able to find it, and my concern is, are we now privileging, again, mainstream media and, you know, traditional mainstream reporters over citizen journalists by allowing for people who are deliberately trying to move from one situation to another where their past connections with industry would be relevant to the public debate? Are we now making it much harder for interested advocates to be able to discover these connections and bring them to light?
Thank you.
Hi, it's on. It's okay, right? My name is Agustina Calegari. I'm here as an ISOC ambassador, but I'm also work at the Data Protection Authority of the City of Buenos Aires, which is inside the Ombudsman Office, a human rights organization. So I would like to highlight two issues. The first of both is my personal view. I do agree that we have to get rid of the term right to be forgotten, but we are all here saying that we have to have the same rights online or offline, so I don't think we have to come up with a new name with the right of privacy and the tension between right of privacy and right to be forgotten, and also with the self-autodetermination. We can address this issue. Or at least we can try a little bit harder. And I don't believe that the name right to be forgotten is eventfully, has a very powerful meaning. It's not casualty that we are calling like that now. And in our region, we don't want to forget. So that's why I think that sometimes we have to change the name of the thing to start address the issue. The second thing I would like to highlight is now I'm talking based on my work at the Data Protection Authority in Argentina in the city of Buenos Aires. It's a local authority. We have a special law on data protection and privacy. Before you were saying about the importance of access to justice. So at the Data Protection Authority, we believe on the administrative way to address these issues, not only the justice way, because we have received a lot of cases where people don't have access to justice and we have to give them solutions too. Nothing else. Thank you.
Thank you very much. I think we have now very nice contributions to talk about. I don't know if you would all like to intervene like 2 minutes to wrap up some of the nice comments that were done. I will just remind you, we're talking about extraterritorialities, the main issue first addressed by one of our commentarists. I don't know if that's an English word, but public knowledge, also talk about the abuses that this process can show from a point of view of the gap between the main media and the citizen journalism. And finally, Agustina raised up again the issue of the name and makes an interesting deduction from a data protection authority point of view. So would you like to start, Kelly?
I cannot give comments on all those points.
No, you choose.
I will just give my own comments. So it seems like we're talking about like right to self-determine which information should be online about myself. Then why don't you recognize a right for my publication to be searched online? So we are talking about R2BF, so right to be de-indexed or de-linked, and we should be clear about the fact that this right applies on information that are not illegal but became irrelevant and obsolete to be indexed. Well, that's a very vague standard, I must say. So about like Mexican cases, so on revenge porn, Korea have specific law that criminalize dissemination of revenge porn, because by definition, revenge porn infringes on privacy. So you don't need R2BF to stop that. And also, cocaine bucket challenge video case can be solved on classical privacy paradigm, just as revenge porn, because the friend just shared the video believing that. I mean, the girl just shared the video believing that the video will not get. Okay, battery is running up. Will not get out, and their expectations were, disappointed. So you don't need this R2BF. I mean, this theory that you should be able to control data about yourself. So the problem with R2BF, as formulated by Google Spain decision, is that it attacks even data that do not violate common sense of privacy. Also, and there was a distinction about public figures and private figures, but those definitions can constantly change, through the data subject life. For example, like Korea became independent over 36 years of Japanese colonization in 1948, and many people collaborated with the colonial administration and exploited fellow Koreans. And imagine if right to be forgotten existed in the Japanese colonial period. In Dictator Park, who reigned in 60s and 70s, was just one private figure, a military officer who participated in killing independence fighters in the colonial era. Imagine him using right to be forgotten to erase non-privacy infringing but shameful data about him. And 30 years later, he became the president. And so now he became the public figure. But all the data are now gone and they're linked, so the truthful data about him cannot be found. Then evaluation of this private figure who became public figure is become impossible. And yes, so we should not talk about ownership of data and the owner data subject should be able to control their data. We should bring classic theory about privacy here. So if the information is infringing on privacy, okay, the data subject or the injured person may have right to get the information deleted, but if it's about his publicly available data, right to be linked or the index should not be recognized.
I was just thinking that, in fact, what we're dealing with is a huge issue in which everyday life, business, politics, scholarly research, advertising is now being collated and collected and linked and indexed by digital tools. And I think what is happening with this disconnect between court rulings in one place and the implications they may have in other places is that our legal systems are only just starting to come to terms with the technicalities of the occurrences that have already happened. So from a researcher's point of view, when you have students who just click a link and think that in itself is knowledge, we have a situation in which, perhaps to my colleague from the citizen bloggers and citizen journalists, there's a paradox here. The very difficulty in finding information is sometimes a good thing. You need to learn how to search. Maybe it's just become a little bit too easy. And I know that may sound a little bit trite, but it has in fact become automated and easy to link things in ways that we did not expect them to be linked. So I think all the terms that we've been playing around with today are all relevant depending time, place, and issue. So I'd like to see a completely layperson's perspective, that the issue is made clear, and from there the judicial issues that follow clarified, because most people are struggling to come to terms with their private life becoming public life and it no longer being fun anymore. It used to be fun.
Okay, just a few final remarks. Thank you to Professor Giancarlo for your intervention. I personally believe that jurisdiction and extraterritorial application of this right to be forgotten thing are two of the most complicated things in the debate nowadays, speaking technically and in terms of international law and national law in general. Still, it's a discussion that we must have. Google has used jurisdiction to shelter themselves. That's what happened in the Mexican resolution. To shelter themselves, saying we are just a marketing company in Mexico, and the one that does all the indexation is in the Silicon Valley, so go make your claims over there, which is complicated, again, in terms of access to justice for the users worldwide. Secondly, I definitely do not want a French court deciding what Google should be or should erase in Mexico or any other country for that matter. And the third problem is that could also constitute an open doors for forum shopping, which has its own intrinsic problems. Secondly, just to close a little bit, there is also another approach regarding the detractors of the so-called right to be forgotten, which can amount to self-censorship in two aspects. First, because if we know that everything might be online forever, we might stop doing things. As Professor Marianne just said, internet is part of our everyday lives, and even more so each and each day. So if I know something's going to be online forever, I won't do it. I mean, probably we know it's going to be online forever, but that could deter future generations on doing or not doing stuff and amount to self-censorship. And also another approach is regarding revenge porn, or even this girl snorting cocaine in a video. Why are you doing that? Why are you filming yourself? Stop walking in a miniskirt on the street if you know you can get raped. And I think definitely this should not be the approach. So this is everything. There should be a balance regarding these two topics, extraterritorial application and censorship or self-censorship, a balance between protection and free speech and privacy and censorship. But it's definitely not a discussion that should be set aside just because of a dogmatic and an absolute censorship approach to the topic. And let me be very specific on this. Not only discard the right to be forgotten as a censorship thing without discussing the 95% of real human beings and cases that are being affected in their everyday lives and everything that surrounds this topic. Thank you very much.
3 points. First of all, I agree that we have a big problem with the jurisdiction of these cases, because first of all, if the problem that national jurisdiction, if they can have the enforcement to oblige Google to this list in all the web. In the other hand, I think that what happens if China, for example, comes to going to order same things like France jurisdiction a few days ago, and impose these values and this thing of concept of freedom of expression and privacy of all over the world. I think that these cases impact in the architecture of the internet, and we must be thinking in a different solution because the national jurisdiction, it's not completely enforcement to take a solution for this type of case. And second time, I think that I agree that the sensitive data of the person we need to protect, but in most of the case, our actions in the society can be public too. I think that a guy who have a condemn for gender violence, we agree that 5 years after that, they have the self-determination to delete these histories. I think that it's not it's a question to put on the floor. And then, well, I think that other thing is the European system and the Inter-American system have different approach of about perhaps the the content of the freedom of expression for different reasons that you know. Thank you.
Just a few comments. Just to illustrate that Costeja case in Colombia was part of the debate, was in the heart of the decision. And also, as a lot of people from freedom of expression organizations said that we do not believe it's a precedent or a rule that should be taken in the decision, was part. I mean, there were other civil society members, as the data protection one, who desire Costeja case as a way for solving it. I mean, it was not that the court did not study it. But I think there were two main reasons that explains why the court decided not to follow Costeja case. The first one is that we have a private actor who this link, in charge of this link or taking the decision of this link, future claims or requests for this link. And I think we have to learn, or I guess the court understood that when you have tensions between rights, is as important. I mean, data protection is as important as freedom of expression. In Colombia, freedom of expression is a fundamental right that has some relevant characteristics. But those tensions must be resolved or must be solved in our traditions by a state authority, a judge, for being clear. So if you put that in charge of a private company, probably they do not have the obligation, but they do, and they have another interest that are not linked with the protection of rights. It's in charge of the state. And I think, I'm not an expert on that, but even in Europe, the tensions between rights is something that is in charge of authorities. And the second issue that I think was very relevant is that before the decision was taken in Colombia, the special reporter for the freedom of expression published a report about freedom of expression on internet. And in that report, the intermediary liability and the net neutrality was, I mean, part of the promotion of a debate of freedom of the net. And in Colombia, because we have an armed conflict and all that stuff, what the Inter-American Commission of Human Rights says, it's a very important yes, it's a reference, very important for taking decisions. So, and just to close what I think about this topic is that I was listening to all of you, and I think we have to move to uncomfortable spaces. When you talk about this issue with data protection people, with children's rights people, with data protection authorities, with judges, with prosecutors, everyone is trying to pull, to push, and to win the debate. So I can say that in my case, I will do my best for convince people, but also with people that consider the opportunity to be convinced. I mean, it's not a deaf debate, and I think we have to move to uncomfortable spaces. I mean, why, if you are in the IGF, multi-stakeholderism, why we do not have a judge here or a court here? I mean, because if we just start this conversation from civil society, and that's why I'm going to say it again, I recognize the effort of Colombian court to understand how internet works, because I think in other cases what was privileged was what the court thinks before taking the case. So impartiality is really, really important. Yes. That's it.
Okay, so I I believe that we all agree on something. Name is a big issue. There is a real tension, and there is a need for more education. And the only thing I would probably add from what has been discussed both in the morning and now is that I do believe that we also have to blame ourselves. There is also a need for a society education. When a society is only taking decisions for jobs, to judge people, to talk about people based on the Google results and on the Facebook history, without forgetting that you also were a young people that did nice things, funny things, that took risks, there's a problem with the society as well. This is something that Amalia stresses all the time when regarding to the right to be forgotten. There's a problem. I mean, we need to talk about digital literacy with Judge. We need to talk about Savvy Tech, as Gisela pointed out. But we should also start by saying that Internet has put before us, or in front of us probably better, a strong tool, and the way we use that information is only being shaped right now, and either we start also blaming employees and electorate and everybody else, or we're not going to be moving forward too. That would be my small thing aside from the moderator role. But I think we're sharp time, so thank you very much for all of you to be here, and I just hope that this will move forward in a certain moment. Thank you. I know, it's 48 seconds. Thank you very much for the clapping.
Thanks, that was great final comment. And remind us it's also about our society. Society first.